Hello, and welcome to the inaugural show of the Bastine Brief. Thank you so much for joining us. Today, I am joined by three of my colleagues and friends who are board-certified lawyers in the state of Texas. Today, we have with us attorney Yasmin Cuddy of the KGK family law firm. Yasmin handles high-conflict divorces involving child custody and complex property divisions. She is board-certified in family law by the Texas Board of Legal Specialization, which is one of the highest distinctions for attorneys in the state of Texas. Less than 1% of all attorneys practicing in Texas are board-certified. The criteria to qualify to sit for the exam is extremely rigorous, and to then subsequently pass the exam is also very challenging. The certification represents a high degree of experience and knowledge, qualities that Yasmin brings to the table. Yasmin Cuddy was also admitted to practice law in the state of Illinois in 1996, the state of New York in 1998, and the state of Texas in 2009. She has practiced for over 28 years and has practiced family law in Texas for the last 15. Yasmin Cuddy handles divorces and other family law cases from inception through final trial on the merits. Attorney Cuddy has litigated cases involving high conflict, custody matters, and complex property division matters. She has years of experience handling cases for clients in need of a protective order due to domestic violence and has significant experience defending parties against protective order applications. Further, Yasmin Cuddy has experience representing parents and children in Child Protective Services cases in family court involving the Department of Family and Protective Services, which we all know as CPS. Ms. Cuddy graduated from Northwestern University College of Arts and Sciences in 1992 with a Bachelor of Arts degree and major in political science. In addition, she graduated from Loyola University of Chicago School of Law in 1995. When not in a courtroom, she spends her time with her 2 daughters, partner, and 4 rescue dogs in Houston. Welcome, Yasmin Cuddy. Next, we have with us attorney Misty Dennis, partner at Smith, Wilson & Dennis PC. Misty L. Dennis began practicing family law to help families recover and heal from the devastation of life changes. When you're dealing with the people you love most in life, everyone needs someone to help protect their interests and guide them to a place of healing and recovery, says Ms. Dennis. It is imperative to a case that there is open and honest communication between a client and his attorney. That's why Ms. Dennis thinks being candid at all times, whether a client wants to hear it or not, is one of her defining characteristics that makes her a successful attorney. One of her more memorable successful cases was having her client awarded primary custody of his child after proving the mother who was awarded custody under temporary orders was not properly fit to be the primary caregiver. "I feel most passionate about custody cases," Ms. Dennis said. "I believe that every parent has the right to participate in the life of their children to the fullest extent." Misty Dennis is also board certified by the Texas Board of Legal Specialization. Now we have with us attorney Katie Custer. Katie Custer is a native Houstonian who earned her Bachelor of Business Administration, majoring in Finance and Organizational Behavioral and Business Policy from Southern Methodist University. After graduating, she worked for the American Airlines and then for Southwest Airlines as a financial analyst. After returning to Houston in 2004, Katie received her Doctor of Jurisprudence from South Texas College of Law. Katie's financial and business background is a tremendous asset to her practice, which focuses on complex marital property characterization and valuation issues, including retirement assets, stock options, restricted stock benefits, business valuations, and taxation issues. Katie is board certified in family law by the Texas Board of Legal Specialization, and she is a member of the Berta Rhodes Rayburn Family Law Inn of Court and the Gulf Coast Family Law Specialists, along with myself, Misty, and Yasmin. Katie is also a partner at Full & Wider Wilhite, where she also served as a law clerk and an associate. Welcome, Yasmin, Misty, and Katie. My name is Ronique Bastine Robinson. I am the founder of the BastineLawGroup, and this is the Bastine Brief. I am excited to share in this opportunity to have a roundtable discussion with my friends and colleagues about complex divorces. All right. So let's get into the board certification aspect of this. Ladies, you are all board certified, and I would like to know what prompted you to become board certified. Why did you want to seek that challenge? And I'll start with you, Misty.
I was very strongly influenced by my peer groups. So I have been licensed since 1998, but I did not take the board certification until 2019. My background was primarily with the state and with small law firms where I managed the family law department. And I became a part of a couple of organizations in Harris County. Through those organizations, I met some amazing women who encouraged me to become board certified. And so ultimately in 2019, I took the exam to become board certified.
Wonderful. All right, Katie, tell us how you managed to get to the board certification exam.
Sure. I think my path was slightly different. I was in law school, and I got a law clerk position at a firm, at Full and Wider. And growing up in a firm with Don Full and Wider, it wasn't really, I wouldn't say it wasn't really an option. It was just, he took pride in mentoring people, and he took pride in really putting faith and growth opportunities into people. And so he really pushed as soon as I was able. He gave me the experience, the trial experience, the first 5 years of my practice. And then he really pushed for the board certification as soon as I was eligible. And the rest is history.
All right, wonderful. And Yasmin, tell us about your journey to board certification.
Monique, I would say that my experience is similar to Misty's in that I had a government background in New York doing consumer fraud advocacy under Andrew Cuomo and Elliot Spitzer, and moved to Texas in 2010. Didn't even know that board certification was a thing. Was a solo for many years, and then luckily ran into a group of peers that were like, you need to block off some time from your practice, sit for this thing, and get board certified. And initially I was kind of discouraged because there's so many criteria that you have to qualify for. And a colleague of mine, Shelley Gupta-Britsky, was like, just throw everything in the kitchen sink, all of your experience from New York, all of your civil stuff, all of your family law, put it all in. And I qualified, and I studied and took the exam, and I passed it in 2022. And I had been in practice for many years before I decided to sit for it. So I guess the moral of the story is, I encourage everybody out there who could possibly do it to try again until you pass that thing. It's a great thing to be amongst a group of peers that all are certified and can talk shop about Texas family code and litigation. And I think it's a wonderful thing.
And if I had one more thing to add, that I think the common thread here might be that having people in your lives as mentors that come in and they encourage you. And so a lot of the, finding, if you're out there on your own, finding somebody that you can hitch your cart to and really learn from and get that support, because it's a wonderful thing to have.
So my journey to board certification was a little bit different. I didn't have anyone, right? I was a solo for years and years and years, and there was no one who was really mentoring me. I ended up doing family law because I got frustrated doing criminal defense work. I always felt as if I was behind the 8 ball when I was doing criminal defense work, and I never really felt that it was a level playing field. And learning that Texas was a community property state and that everything sort of was a presumption that it was going to be equally divided, even though I learned later that equal and equitable are two different things. But at the time when I made the decision, it was because of that. And so I got into doing family law, and I didn't have people around me who were encouraging me or telling me or even examples. And then Ivy Ricketts got board certified. And then there was someone that looked like me, that talked like me, that talked to me, that I knew. And I said, oh, well, maybe that is something that I should do. But at the height of that moment, I was beginning to have children. And so I put board certification off for a pretty long time. So I didn't do it until I had actually been practicing law for 24 years. But I never lost sight of it, even though I did do the mom thing and not really working very often, or just working long enough to pay the babysitter and then getting back home because you really wanted to be there to be a mom. Because isn't that also why we do family law? Because we understand families and we understand the toll that it takes on families when you got a partner that's out. Well, thank you for that. Let's talk a little bit about what we do and how we do it. When it comes to executive compensation, that's our topic for today. And I want to let you ladies know the reason why I selected executive compensation and board certification together is because of the rigor, the experience, and the knowledge that it takes to really witness and see a case with executive compensation and make sure that you handle that properly. And so when I was talking with my staff, we came up with a title, which was How to Take Out a Giant. And so that was kind of where I was focused, right? Like, oh, we are going to fight for the little person. But then what I realized was, okay, as lawyers, family lawyers, we're always on both sides of the equation. And so sometimes we have what we call non-moneyed spouse, and sometimes we have the moneyed spouse. And so I decided that it wasn't just going to be how to take out a giant, it was going to be how to take out and how to protect a giant. All right, so we're going to talk about it from those perspectives. All right, so when we talk about executive compensation in divorce cases, what type of compensation are you most seeing that is overlooked by, say, your opposing counsel in a case? Yes.
I would say I look at a lot of different things. I think it's critical for both sides to know, how is that person compensated? Is there a base salary? Are commissions involved? Productivity bonuses, restricted stock units being awarded? Is there a pension, profit sharing plan, health savings account? What are all the perks of the position and salary? If you represent the non-earning spouse, your client may not have a clue. So I think you can utilize tools such as discovery, depositions, and get all that information. If the earning spouse is the person who's a CFO or is actually an owner of the company, you may have to add the company to the lawsuit and then propound discovery on that company to get all that information. Getting all the information is critical. And a lot of, I think, inexperienced attorneys maybe don't get all that information. They don't understand the breakdown. They don't know that this person is entitled to a profit sharing plan and RSUs and how does that all work. So, just to kind of give you a broad overview answer, that's what I would say.
Okay. And so I'm going to toss it to the business major. Why don't you help us understand, well, not us, who we know, our audience here, what is a restricted stock unit and how does it function and play into executive compensation?
So restricted stock unit is it's an equity-based asset that an executive will receive for their employment. Oftentimes it's tied to future employment and it has, they're awarded and then those units will vest over time. And so it encourages longevity in a business for top level employees. And so the importance of understanding if your client has them or if you represent the spouse who's married to the client who has them, it's important to fully investigate these because a lot of times, in Texas, because it's an inception of title state, it's really important to understand when those rights to those awards were received. And if it's during marriage, and even if it requires post-marriage employment by a spouse, there is a portion, 3007 in the Texas Family Code, there is a portion of them that will be considered community property still, even if they vest outside of the marriage. So that's the restricted stock unit in a nutshell. And all right, it's important to understand getting the grant award usually will have the date of the grant and the way that they vest over time.
Okay. And so when Yasmin was talking about the discovery process, what do you do to say, hey, I know for certain that these have been granted? How are you going to get that information if it's not turned over to you pretty immediately?
The company will have that information and you can subpoena a company directly if you need to. Oftentimes the courts will intervene, even if it's an arduous process to get that information. But if a company offers restricted stock units, there is a grant award, there is, there's an agreement that will outline all of that information. And so it is there. You just have to, you have to get it.
And Misty, when you represent the spouse that is not the employee, how do you assure them that you're going to find everything that is part of this person's compensation package so that they know that they're getting a fair and equitable division?
So I can never assure anyone anything. I can never assure. But what I can do is information gathering, right? That's the most important thing. Talk to your client about what they believe is there, what they believe is out there. The best thing that you can do is make sure that you tailor your discovery requests so that you're getting the specific information you need. Often what happens is attorneys send very general discovery requests, right? And you're asking for general information, and you're not tailoring those requests to ask for these things that you specifically believe are out there. The other thing is, like Katie said, subpoenaing the documents yourself, subpoenaing the company that they work for. Because one thing about employers is they want a CYA. So they're going to put stuff in writing, right? And so there is a document somewhere that says what this executive is entitled to, when the stocks were granted, what the basis of the stocks are, when they'll be entitled to them. I mean, we're talking about stocks here, but there's a whole litany of other things that come into play. I mean, there are, when we talk about perks, right? Company jets. We talk about club memberships. Those are all executive benefits that people are entitled to that can come into play when you're talking about dividing somebody's estate.
So let's talk about that, because when we have perks, right, you have the spouse that has said, look, we went to Italy on the company, we went to France on the company, and, we get private cars and we get all these different things. And so that is a lifestyle that we have benefited from. I want to make certain that I'm receiving what I'm supposed to receive. What do we tell them? What are you guys saying to your client that says, this looks non-monetary, but it is quite valuable?
I would, that's a great question. I would say, it just depends on the circumstances. I do represent a lot of South Asian clients. I'm South Asian myself, and a lot of them are entrepreneurs and they run small businesses. And I think your question brings into a lot of sub questions, which is a lot of times when people run their own businesses, they pass through income. They are expensing things that they are paying their mortgage and the grocery bill and the private school through the company. And all of a sudden, you're living a really high lifestyle. Your house is paid off, you have fancy cars, your kids are going to private school, but the tax returns are reflecting less than $50,000 a year in profit. Well, you've benefited, the non-earning spouse has benefited from all this all these years. Taxes may or may not be properly being reported. Income's not properly being reported. You probably need to get an expert on board to go through the returns, go through the profit and loss statement, see how much income is being passed through the company, what's actually legit, what's not, and where is that income? Is it being hidden through passing it through? Is it an S corp? And those are the kind of questions that make it impossible to really give your client a definitive answer until I think you get further into the discovery. And sometimes you're out of luck. It just depends. So you may have benefited from it, but it's not being properly reported. And so the court's going to look, in my experience, at the returns and seeing what is this person reporting on their income tax return. And it may be difficult to give your non-earning client the lifestyle from which they were used to being in after the divorce.
And I think the same holds true with some of, like, if you have a major corporation who's providing some perks, like you could try to value what that is to the community. You could, but again, how is it being reported? If your client's not, or their husband, your parties are not reporting it as income, is the court going to treat it as income? So I think it holds true. Very good point on the pass through and income on the S corp and the small business owners. But I think the tax returns also provide a pretty good roadmap for maybe what a court's going to do with the income.
I think it's also important to elicit the testimony from your client in regards to the benefits, right? When my husband started working for this company, they provided a company vehicle. We had an $800 car note. That $800 car note has gone away. That's a benefit, right? Some of these things don't necessarily have a monetary value, but I think that the court can take them into consideration when they're thinking about the benefit that the executive spouse receives from the company when they're looking at dividing the estate in a totality, right? So yeah, he may only earn $400,000 a year in actual cash, but he has another $100,000 a year in benefits. And so when the court is considering the division of the property and they look at disproportionate earnings, they can take that into consideration when they're looking at the disproportionate earnings when it goes to dividing the entirety of the estate. So, of course, it depends on what court, what judge, what the totality of the circumstances are. But I think as an advocate, it's our duty to put forth all the facts, right? Put it all out there. Throw everything in the pot, kind of like you said earlier, and then leave it up to the court to make those decisions.
So what are you seeing that your opposing counsels are missing, right? So we're all here and talking about, why we became board certified. And sometimes we're going to get less experienced attorneys that are going to be on our opposing counsel. What are you seeing that they're missing when you know that you have a highly compensated employee that you're actually representing?
So I will say recently, we talked a little bit about the stocks, right? So restricted stock units, future grants. I have seen that maybe they don't fully understand what that means in the sense that, okay, they have this option, but they don't actually have the stock. So we're not going to take that into consideration in the division. But that's absolutely wrong. There is some benefit to it. And although you may not be able to put a monetary value on it right now, you can always protect your client by including language if and or when this is granted, the marital portion, the community portion is this. So that's something that I see a lot of people missing. I also see people missing things like bonuses for not just bonuses for work already done, but for an example, change of leadership bonuses or promotion bonuses, like in future promotion bonuses, things that were earned during the marriage that may not come into play until after the divorce, which can still be looked at as part of the marital estate.
What have you guys seen?
So I always tell clients who come in, usually it's the non-earning spouse who'll come in and not sure what the earning spouse is, how they're being compensated exactly. And so a lot of times we talk about what one doesn't look like a paycheck. Like you get your W-2 earnings, maybe some K-1 distributions, but for executives, there's almost always more. And so you were talking about, change in control. And sometimes there's other, they call them the golden parachutes, so the retention plans to keep people on board. And it's a promise of a payout in the future. But as you're promised to be payout in the future, you're chiseling away at that asset. And so that may have some value during the marriage, even if it's a promise to pay in the future. I mean, it can be a gray area because if there's some other follow-up questions on, how's the volatility of the company? Is there potential that this that the employee can be fired and stuff like that? But there's always more than just the paycheck for the executives, and so it's important to look at all of those things. And just because it isn't something that they're realizing today doesn't mean that there isn't some sort of attachment during marriage or grant or ownership interest in marriage that would put a value on something that's paid in the future.
And what do you see? What do you find with the opposing counsels missing that they're not asking you for?
If I represent the earning spouse, I think that I would say I've run into issues where the attorney is less experienced. They don't know how to tailor the discovery to ask for the specific kinds of questions. They don't really have a good grasp of what the compensation package really is. Obviously, it's my duty to respond to any discovery request and be transparent, but I have no obligation to educate the other side. So I think I do see that I don't run into that as much when I have an opposing counsel on the other side that's also board certified. I will say I do run into it with less experienced attorneys not doing their due diligence, not knowing what kind of questions to ask for, and really not maybe having a total grasp of what the compensation package is. Does my client have a real ownership interest in the company? What does that mean? Was the formation documents done, did inception of title, did it happen during the course of the marriage? Was this a company or business that was started before the parties got married? The other side not really having a good grasp on that, I think, is something to be really wary of for the non-earning spouse being represented by somebody who isn't as experienced.
And I would also say that I think what you were saying kind of just struck. We all talk about the employee compensation package. That is a document. Whenever anybody in a high profile or C-suite position gets hired, they are hired with a contract, and that contract is going to have their employment, their employee package. And so that's a great place to start, and it's a great thing to ask for, and then drill down from there. I mean, sometimes you might have to hire a compensation expert to understand all of the things that the people are compensated with. But it's a great place to start in your discovery quest.
And how often have you seen anyone actually ask you for that packet?
And I would say it depends. I think it may be 50-50. It's not something, and again, transparency is something that I think that we all sitting at this table find very, very important in our practice. But again, it's not your job to educate. And so be careful what you ask for or what you don't ask for. And if it's not encompassed in what the discovery requests are saying, then it's not something that my client is going to give to me to produce. But it is, so I would say probably 50-50 that somebody asked for it. This just depends on, I guess, the opposing counsel.
Yeah, and I would say advice to the maybe lesser experienced opposing counsel, and I mean, I'm not an expert by any means, but I would say, hey, subpoena the employment records right off the bat. Don't even wait for anything. Just go ahead and issue your subpoena and get everything from the company. If they're a Fortune 500 company or in their oil and gas companies, they're going to turn over all that information right off the bat, and then get somebody to sit down and explain it to you. If you don't understand it yourself, get an expert, get somebody as a forensic accountant to sit there and explain how is this thing structured? What is the compensation package, and educate yourself.
And so let's talk about that a little bit, about those subpoenas. All right. So when those subpoenas go out and they just have some, very generic, also very vague language, do you ever get a response back from like an HR department or anybody that's basically saying, we don't know what they're asking for, or we only have basic information? Like you said, your Fortune 500 companies, they'll turn over everything. But if you get some of these smaller companies that still have highly compensated employees, they're just smaller companies. Are you ever getting any responses back when you send those subpoenas out? That's just like, we don't know what you're asking for.
I would say more often than not, the last battle any company wants to have is a legal battle in the middle of a force. And they're not going to necessarily fight on wordsmithing a subpoena. Typically what I've seen happen is if it's not sufficient or they don't understand, I'll get an email or a phone call and they'll say, hey, what is it that you're looking for? We want to be compliant. We want to get this information. We don't want to be involved. I just need to understand better what you're looking for.
Have you had the experiences, Laura?
I haven't. Not often. I think my experience has been very similar to Katie's. If they're not clear what we're looking for, then they usually will reach out and ask. But typically we get the information that's requested.
It's been our experience that we have had a bit of both. We've had situations where an HR department has basically called us and said, we don't know what this is. We understand that you represent our client. We don't want to not provide the proper information that the other side is asking for, but we want to know what you are, what would you advise us? And then we've had the other side of that where they're just waterfall. You get like a whole stack of documents. well, like you said, be careful what you ask for. It's like, okay. And so I've seen both sides of the coin. And so that's why I asked the question.
Well, I will say that if it's a smaller company or it's not an arm's length deal, like there can be some games played and there can be some hiding the ball and stuff. So that does definitely exist.
And I'll issue a subpoena to the CPA or the CPA company that does the accounting for the company. If like the stuff I do get back from a smaller business is kind of inadequate, I'll get the records from the accountant and then depose like the partners and, make it tough and get them in and get them under testimony and start digging up and gathering all the information about the way this company's run and what are they doing. And it does drive up the cost of the case. I mean, all this is time and money. So,
right. And so what happens though? Because have you ever felt like you were going through a discovery battle and you were just trying to gather, only to find that there just really wasn't that much at the end of the rainbow?
Yeah.
And, you got to kind of tell your client, like, well, we didn't know what was there. You didn't know what was there. But now this is the cost that we've all incurred. Yeah.
But I think it's a price of peace too. And I think that you don't know unless you ask, and it's just always a cost benefit analysis that I think you have to go through in every case where, you say, this is what we know what we know, and we think we know what we don't know, and we need to bridge that gap. And there's some definitely consequences if we don't bridge the gap. And it's a risk. Do you want to take that risk? Do you want to spend the money to try and bridge that gap? There may be nothing at the end of the rainbow, but there might be. And ultimately, if a client's involved in those kinds of decisions, there's not always the welcome paying of that bill, but it's a little bit easier pill to swallow if it was a joint decision to make. But I think at every turn, there's always a cost-benefit analysis and digging a little bit deeper.
When Yasmin started talking about deposing all those people, my heart a little like the wolf. How many depositions are being done?
Well, that's why you have those conversations with your clients before you do it, right? So that they understand, hey, this is what you can anticipate. This is what it's going to cost. This is how much time it's going to take. This is, the possible outcomes. We may get something, we may not get something, right? I mean, if you have those conversations with your client prior to making those steps, then it certainly should make it a lot easier for them when they get the bill, because they know that it's coming.
Yeah. So let me ask you, what red flags should practitioners and spouses be aware of when an executive compensation package is part of the marital estate? And so when I say red flags, I mean, what should the executive be looking for when they come to you to talk to you about a case?
The executive red flags? I think honestly, the conversations that I usually have with the executives is that, especially if they're at a Fortune 500 or a bigger company, a lot of times compensation is published or it's out there. So it's like, this isn't the battle that we want. Let's just give the compensation. Let's figure out what our exposure is. Oftentimes when I meet with somebody as a potential and they come in, one of the first things that I really try to do is understand it myself before I'm sending the information out to the other side. I want to understand what it is what the exposure is, so I can have that conversation with my client. And sometimes it doesn't go well at first, but I can't change the law and I can't change the facts. But just understanding, I don't know that it's necessarily a red flag, but just understanding what the compensation package is and what may be on the table for division and having that conversation. But truly, like, the transparency of it all, it's not worth the fight. Like, let's not spend the money here. It's not your battle. Like, we can come up with legal arguments and stuff like that, but giving the information is not your battle.
What about you, Yasmin? What do you, when you're counseling the executive?
Yeah, I would say chiming in with Katie that they've got to be transparent with their attorney. So if your client, who is the earning spouse and is the whatever CFO or high up in a company, and you sit down with them, they've got to go ahead and give over all the information and cooperate and not play games and tell you what's going on and what the compensation package is. If they're not being transparent and they're not being forthcoming, that's a red flag. I would say you probably aren't going to experience that with bigger companies like oil and gas and those or medical centers, or people who are maybe physicians or working for large companies, but people who run smaller businesses that are lucrative, you will definitely get some gamesmanship with your own client. And you got to be able to sit down and have real conversations and then decide whether or not you want to move forward with representation with them. Because if they're not going to be transparent with me, I'm not going to stay on the case or be on the case. So that's my red flag.
So let's talk about red flags with the non-employee spouse. What are those red flags? When you're counseling that non-employee spouse, what are you telling that non-employee spouse to look for?
Lifestyle, I think, is a big thing because, kind of full circle. They don't always know what's there, right? They know the paycheck. They don't always know what the paycheck is. They don't always know what the income is. They don't always know what the benefits are. And so, a lot of times the non-executive spouse doesn't have a good understanding of what's out there and what's there. So making sure that they understand the time and the cost involved in getting the information that they need in order to pull these things into the division, and making sure that they have an understanding. To backtrack a little bit, sometimes what I find is even the executive doesn't have a full understanding of what they have and what those things are, what they mean. Is it income? Is it property? How the court will look at those things. And I think not only educating the non-executive spouse, but educating the executive spouse so that they understand what things the court can consider when they're looking at dividing the estate. But doing the same with the non-executive spouse, making sure she understands, well, just because he gets to use the company jet, that doesn't mean that you're going to be able to use the company jet once the divorce is over. So again, not really a red flag, but making sure that they understand. Making sure that they understand that they have the more difficult job here because they're the person who has to get the information as clearly as possible to relay to the court, to include in the estate so that it is subject to division.
Okay. All right. So when we are talking about the red flags, and I guess everybody can say the red flag, it's not really a red flag. They're always red flags to me. And they're red flags to me because it's something that Yasmin said, is that you don't always get full transparency from your own client.
Sure.
And so that's why they're always red flags to me. That's the red flag I'm looking for. Like, are you being honest with me? Like you said, like, let's not fight this battle, because I've had the privilege of representing both sides of this coin. And it's true, when it's out there, it's out there. It's public information sometimes, right? And I remember having a client who said she brought his public information to me. That's not always the case, but, she came in and she was very prepared. And she was like, look, this is his compensation package. These are all the things that he gets. I love having an educated client. I love when they understand exactly what it is that they have and where it is that they're going. And I do believe that transparency is one of the things that, we all appreciate. And if you don't have transparency with your own client, that you are feeling a bit like, I don't know that I want to be in this with you, because I don't want to lose my reputation with my colleagues, with the court, because I'm trying to help you with this gamesmanship, as you said.
Well, and then you get the transparency where you're like, oh,
That's more than I wanted to know.
so we're admitting we're doing this.
Okay,
That's a red flag. I'm not, especially with the smaller companies or the split, and they're like, well, I'm just not receiving a paycheck anymore. I'm like, well, that's not how that works. But I've had, people come in and they, turned off the faucet because they're going through a divorce. And I'm like, how are you going to sell it to a court that you have previously made, X amount of money on your tax returns, not even counting all of the, personal spending, but on your tax returns. And now all of a sudden your company is not doing great and you're not paying yourself a salary. So yes, there are red flags, and it all ties into the transparency issue. And sometimes there could be a little bit too much transparency.
Well, the red flag is for the client, for the person, the potential client who's coming in. Not so much about the case, right? About the executive compensation, because I mean, that is what it is, right? But we always have to be cautious of whoever we take on as clients, regardless, right?
Can I chime in a little bit on this? The question that you asked Misty about if you represent the non-earning spouse, what's a red flag with that particular potential new client? I would say, I think all divorces, regardless if you're either earning or non-earning, is a step down socioeconomically when you get divorced. You're dividing your estate in half, however you're going to cut it up. And I think sometimes a red flag for me for the non-earning potential new client is really understanding the reality check of what that's going to mean. Because a lot of times they end up, you dig around, you get the discovery, and you find out maybe there's nothing really there. Your earning spouse made a ton of money, but you guys blew through all of it. There are no retirement accounts. There's no savings, especially with smaller lucrative businesses. I see the money's just poured back into the business. There's not a lot of individual bank accounts and properties to divide. And when you get that information and you relay it back to your client, that's the non-earning spouse, they can't accept it, or they think you're not advocating hard enough for them, and they don't want to see that reality check. That's a red flag for me. And sometimes I get off the case and say, hey, maybe you need to go see a different kind of lawyer, because I try to be as transparent as possible and start preparing my client through that process and educating them. Your lifestyle is going to be different. You are not going to be able to afford living in a $500,000 home if you're not working. You know, there is really very few cases where clients get alimony and post-spousal, post-maintenance divorce payments. It's very rare. And so they have to be able to afford even what they're getting to be able to maintain a certain lifestyle. Sorry.
I completely agree with that. There's both sides of the reality checks.
And so how are we seeing our courts looking at this? Because you brought up spousal support, right? And we brought up the things that can't be necessarily monetized, right? You can't monetize his ability, her ability to use the company jet, right? So how are we seeing courts compensate for these, for either our executives or for our non-executive clients? What are we seeing when courts are dividing these estates?
I think that's a very broad question. When you say, how are the courts?
What are they?
Right? So what am I seeing? What am I seeing? I'm seeing that these judges are smart. I'm seeing that they have a decent understanding of these executive compensation packages, what these things are, stock options, these bonuses, these long-term incentive plans. I think that they are having a good understanding of what they are. Now, of course, it's our job to present it in such a way that it's clear and understandable to them. But when they're looking at that, they are dividing these things equitably in the way that they should be. So I don't see that people are able to hide the ball. Going back to what Katie said, like it is what it is, right? We know that it's going to have to be divided. Let's not fight this battle. Let's put it out there. And I think that in most cases, the courts have a good understanding of what these things are, and they're dividing them as they should.
I add to that, I think once you get to a point in a court and you've got the characterization of each of these assets appropriate, and you're putting that in front of the court, I do think that the other things that the court can and do consider is some of the, for some of these assets, there's going to be tax liability. There are plan restrictions. And so I do think, and I do, in one of those things that gets left on the table with some of these compensation packages is not just the discovery and the figuring out how to frame them and put them in an inventory with opposing counsel. It's not asking the court to consider certain things on the tail end of it. And that's like if you have the non-earning spouse who might be living in the $500,000 house with a mortgage, and you're awarding her restricted stock units that she may or may not see for 10 years, that doesn't help. And so when you're making your relief requested to the court, it's important to realize what the assets are that you're asking for your client based on who your client is. And if it's a non-earning spouse, you're going to want more cash up front rather than getting her, something that may look great in the distance. Even if you have to take it at a discount, I think that's important to look and ask for. And I, if you do present them those scenarios to a court, I do think they take that into consideration when they're dividing the overall estate.
Right. Well, thank you, ladies, so much. We are out of time, but I have appreciated this very robust conversation, and I appreciate each of you participating in the inaugural show with me. And to our audience, thank you for joining us for the Bastine Brief. We look forward to seeing you in our future episodes.